Okay, Mr. Snell.
My Lords, I'm now addressing the policy reasons why you shouldn't be required to look at the prosecution file, and this is really Court of Appeal at paragraphs 58 to 60, which we obviously say they were right for the reasons they gave.
Yep.
First point, unlike equivalence in general, there is no legislation attempting to harmonise the approach to prosecution history, nor in our submission is there any clear direction of travel amongst EPC states. And that's perhaps not surprising, given that there is no jurisprudential basis for looking at the file. We would say that a judicial peak basis is not enough. And if there isn't a legal basis to look, then you shouldn't look at all, particularly with the practical problems that that brings. And even though there are a number of countries which do look at the file, there is no harmonisation as to what they look at. Some only look at the application, others only look at clear and unambiguous statements made to limit the scope of the claim over the prior art, others look at everything. But even then, it's striking that there are no cases in any of the jurisdictions before you where any court determining the merits has been shown to rely on a narrowing of a claim for added matter reasons only. And we say that's particularly surprising given how common it is to have this objection arise in prosecution. And the simple reason why there are so few cases on it are the recognisable difference between disclosure and scope, as I've pointed to and as my learned friend accepted yesterday. Now, he relies on the AIPPI as recommending further harmonisation. It's perhaps unsurprising that when a group of patent lawyers were allowed to get together, they recommended they should be allowed to look at the file. But if we take it more seriously, even if the recommendations they made are implemented, they wouldn't touch on the present case. The recommendations can be found in the supplemental bundle, tab 2.
Right. Yep.
And your lordships will note that in the background section, paragraph 3, they record that in 1998 it was resolved that they shouldn't look at the file. No one should look at the file. That's the description shall not have any effect on the scope of disclosure. Paragraph 4, by 2003, they were recommending that only express and unambiguous statements to overcome a piece of prior art should be looked at. And now in this recommendation on page 5023 at the bottom, we see paragraph 2, the primary suggestion is that the primary source should be the patent itself,
Yes.
and statements made during the examination process that purport to limit the scope of a claim should, as much as possible, be added as limitation in the claims or, where appropriate, as disclaimers in the description or drawings during the examination process. So this meets Lord Mance's point, is how are you meant to limit, and you do it by disclaimers in this way. That's what they recommend.
What's the words "as much as possible" mean?
Well, I think it's suggesting that in not every case would it be possible to do that.
Suggesting it's a case of construction, or what?
Or an express statement in the patent that you are excluding the scope of the claims in a certain way. That's how they're suggesting it should be done, because the primary source should be the patent itself. That's the reason behind it. They say in certain circumstances, under 3, they should be taken into account. And the 2 examples they give is paragraph 6, if there's ambiguously worded claim features, you can have some assistance from the file. Or in paragraph 7, a clear and unambiguous statement made whereby the applicant disclaims or abandons part of the scope of protection that would otherwise be included, and the scope of protection shall be limited in post-grant proceedings. Even if all this was taken on, my lord, and assumed to be the legislation, we submit that this doesn't touch upon the file in the present case because there is no clear and unambiguous limit of scope. My lord, the other document my learned friends referred to yesterday in support of their submissions was the Peeler and Torreman's book. Unfortunately, for some reason, the paragraph in issue had been cut off halfway through. Can I just hand up the missing page, because it does present,
quite a good idea.
It does present the other side of the case. And this is in bundle AV4 at tab 4.
Yes, that 1.5 page, yep. So there is another half to it, right? Yep.
And the Lords will see
Thank you.
So where does this document go?
It goes in bundle AV4, tab 4.
It's a new page.
It's the last
Got
page.
pages 201 and 202, you're giving us 203.
My lord, yes. And you'll see the authors in the bit you didn't have
Yep.
suggests that the file is directly analogous to pre-contractual negotiations to determine the meaning of a contract.
Yeah.
And they go on to say, well, on the one hand, you might be able to look at the file. On the other hand, the patents should stand on their own. So we say that they're not taking a position
Right.
that suggests we should definitely
They
do
won't.
it. My lords, the reasons we say there's a lack of harmonisation is it's well recognised that the benefits of ever looking at the file are marginal at best and far outweighed by the effort and expense. So most jurisdictions attempt to rein it in one way or another. More important point is that you should be able to determine the scope from the claims in the light of the specification. My learned friend was right to say there's no enlarged board decision on this point, but that's because the EPO so rarely looks at the scope of a claim as opposed to its disclosure. The best we can do is the Boeing Company case, which we refer to in paragraph 71 of our reply, which is a technical board of appeal, where they said effectively you should be able to get everything you need from the published text of the patent. So if anything, the EPO suggests that the patent should be enough on its face. It's paragraph 71 of our
Yep,
reply.
have it. Yep.
Now, my lords, activists say, well, it's still necessary to cross-refer to some materials, but of course we say the common general knowledge doesn't need looking up by definition, and the patentee is required to write into the specification the pieces of prior art that come up during prosecution. So you have all that, again, on the face of the patent. That should be enough. My lords, as far as practicalities go, our submission is the fact that the prosecution presented to you in this case, the 4 letters, is relatively short and in English, doesn't mean that that justifies examination in all cases, which may be both significantly longer.
No, we have that. That's why we asked the questions we did.
Yes, my lord. And of course, the other official languages are French and German
Yes.
in the EPO. It's said that all the communications are public. It's right that the documents are made public on the website, but as your lordship will have seen from the document handed up, and your lordships will know from practice, you can also deal with the EPO by phone and by an oral hearing. And the minutes of these phone conversations and the oral hearings are very limited indeed. So it's very difficult to get information from those. So the entire file is by no means found.
Understood.
My lords, in terms of the document that my learned friend handed up this morning, we're not quite sure of its status. It appears to be a description of the sort of job you might get at the EPO if you're applying to be an examiner. This was the document he handed up this morning.
Perhaps he thought that the court could benefit from that.
Yes, I mean,
Yep.
I don't dispute that this is an indication of what the examiner does, but it's certainly not official guidance.
Thank you.
And your lordships will see in the bottom left-hand corner, there's no limit to the number of times that the proprietor can respond. There's express reference to oral proceedings, and in the right-hand side, express reference to personal interviews taking place.
On the other hand,
at
one
any time.
presumes that the statement in the second letter, in this case from the office, saying that this is your last chance is not unusual.
No, but in many cases, there'll be far more than the 4
Understand.
letters in the present case,
Understand.
just on the prosecution.
Understand that.
And in fact, my lords, in the present case, the file is some 2,300 pages,
Right.
containing 491 documents. And the reason for that, of course, is that the post-grant opposition is part of the file. So although there may have been a relatively limited number of documents in the early stages, that expanded when Teva opposed the patent.
Understand.
And during that post-grant opposition, of course, there were written submissions from Lilly. There was a 2-day hearing in The Hague
Yep.
at the opposition level. And if all that has to be gone into to look for statements, we say the burden is really enormous. And this is the point that your lordships made about it's all very well saying just look at the relevant extracts, but you have to find out which the relevant extracts are. And although my learned friend said that the electronic system is indexed, it is indexed to a very limited degree, and you have to go into most of the documents to find out what they are. You can't tell from their title. And in relation to this post-grant aspect, my lords, can I draw your attention to a recent decision in the Court of Appeal which refers to the possibility of opposition proceedings being used to try to restrict the scope of the claims. It's at bundle AV1, tab 6. So it's Authorities Bundle, volume 1. And it's the same court, in fact, constitution as we had in this case, IPCOM and HTC. And if your lordships would just turn to paragraph 57, which is the judgment of Lord Justice Floyd, on page 2490, and perhaps your lordships would just read paragraphs 57 and 58.
I mean, here he is relying on his own judgment in this case.
Well, he goes a lot further than that. He certainly does to start with, and I'm not relying on that part of it, my lord. What I'm relying on is the fact that they were attempted to rely on the opposition proceedings, and as he records in paragraph 58, the inquiry before the judge into what happened before the TBA involved receiving evidence from no less than 5 witnesses.
I see. Sorry, I hadn't seen that. Thank you.
Including 4.
I have the point. Thank you. Sorry, my fault. Yep.
And the last sentence of 58, we say, amplifies the reasons given in the
I
present
see that.
judgment.
Thank you.
This was proceedings before the grant of the patent, was it?
No, this is post-grant, my lord. What happens is the patent is granted, and then...
And then it was challenged, and then there's a final form.
Yes, but that's all deemed to be part of the original
It's all part of
prosecution.
the opposition proceedings were
Yes.
really part of the grant.
And the reason, my lord, for why this is important is because it's very common in these proceedings for the claims to be amended, as we've seen, and so reliance can be put on statements made and reasons for amendment.
What you're saying is once you go into one thing to go into a few letters, it may be another thing to go into opposition proceedings.
My lord, yes, and there's no legal basis to draw the line over
Understand.
So, my lord, Actavis' submission that looking at the file will never involve witness evidence is clearly not right, as can be seen from the attempt in that case to call witnesses, and you may need expert witnesses as well. So, for public policy reasons, we say the additional costs of studying, translating and arguing the points in court all point against it being accepted. Actavis suggests it creates certainty to look at the file. We suggest on the contrary, it creates uncertainty because it raises further arguments of interpretation.
Yep.
And because people are alive to this, patent attorneys are alive to this, the prosecution history will rarely involve a discussion about the scope of the claims, and therefore the purpose of looking at the
As
history.
you've said in this case, the letters were quite carefully written.
Indeed, my lord.
Okay. Point on.
The answer to all of this, of course, is, well, if you say that the claims are invalid, if they're extended to cover a certain embodiment, then you should challenge validity, as most people do in the UK, and that's the fairer way to deal with it, particularly where an examiner may take a point that's not right. And so if you are forced to amend for commercial reasons to get your patent granted, and you're then, that original decision by the examiner wasn't right, and you're then bound by some sort of estoppel, you'll doubly pay the price twice, and we say that's quite unfair. All it does is encourage cost and satellite litigation, and for all those reasons we say the Court of Appeal was right to make the decision it did in the terms that it did in paragraphs 58. So, my lords, that's all I was going to say on prosecution history, unless you have any other points. My final roundup is the foreign decisions, and that's the note I handed up before the short adjournment. So this is what I was going to say on the foreign decision.
You did indeed hand it up, and I have foolishly left it in my room. If you've got a spare copy, I'd be grateful.
I wasn't going to admit it, but I'm in the same position.
3 spare copies, please.
Well, I have my copy, and I read it as well.
So did I. I'd still like to have it.
Lord, I'm struggling, I'm afraid, to find.
Okay, Lord Clark goes to the top of the class.
There's one clean
I
copy.
refuse to answer any questions.
exam.
You're making up for having lost the other one.
Have you got yours, Patrick? You've got yours.
Yes, I have.
Thank you. My Lord Hampton.
We've located the spares, my lords. We now have.
No, that's fine. Thank you.
So, my lords, this is what I was going to say. Having handed up the note, it may be easier if I now don't need to say it to save time. But very briefly, our overall submission in relation to the foreign jurisdictions on prosecution history is that the reasons I've taken you to as to why prosecution history as a matter of UK law doesn't limit the scope is equally applicable to all of the foreign law jurisdictions. In terms of direct infringement, moyen general, moyen particulier, we say the only material before the judge was the joint textbook and the Dell decision. There was no material going the other way. There were no examples in any of the cases which activists rely on where there was a combination with a novel function. Mundipharma doesn't help, and therefore we were right for the reasons I gave in opening. My lords, if you could just write down on the bottom of prosecution history, paragraph 162 of the judgment, where the judge records his observations in relation to the Hewlett-Packard.
That's a judgment of Justice Arnold.
Yeah, yes, my lord,
Thank
that's
you.
right. And he says, in particular, prosecution history is relied on to distinguish from prior art. It's not the case here, and shouldn't be used where it could be said that the new claims have the same scope as claims that are being abandoned, and we say that's not the case here either.
Very well.
Not what we're trying to say. My lords, Italy, conscious limitation. This was the only case that Mr. Raphael took you to as said to be a clear example of prosecution history and added matter being relied on. My lords, a close examination of the case shows that it doesn't go as far as Mr. Raphael suggested it did. In particular, it is only a summary decision to discharge an interim injunction, and all that the court did was record the arguments about added matter. They recorded the fact that there was a court-appointed expert who didn't think it was added matter, and they said this is all rather difficult, and it wasn't clear enough that there was infringement, reasonable certainty they were looking for, and therefore they lifted the interim injunction. So this point was still to be determined on the merits, and we don't have any record of what the court did on the merits when it decided this point in full. So this case doesn't support activists' submissions. We also make comment on the WLP case, which we say doesn't assist activists either. And in terms of prosecution history, we again, if you could write in the margin, judgment paragraphs 174 to 175, we say those again demonstrate on the facts that I've taken you to that this could not be said to be a conscious limitation.
Very well, thank you.
In Italy. Finally, Spain, my lords, this is where the country that's closest to Improver 2 and 3,
yes.
We refer to Rambaxi, where there was no evidence filed by the patentee, so it's not surprising the court found as it did. On prosecution history, it's clear that in the Rambaxi case there, it was undisputed that the amendment was a limitation in scope. That, of course, is very much an issue in our case. And the Ross Rocker case doesn't help either because it was a case about prior art, not about added matter. So, my lords, for all those reasons, we say that questions 2 and 3 in Spain would be answered in our favour, and on prosecution history, on the facts, there was certainly no compliance with the quite high standard that the Spanish court applied as recorded in the judgment at paragraph 184. So, my lords, unless I can assist you further, that's the foreign law. The final 2 points, my lords, if I may. Firstly, on examples of equivalence and the best examples in chemical cases. What we've done is just to write a note with the best cases in the foreign jurisdictions in the bundles which deal with equivalence in chemical cases. And so if I can hand that up to your lordships, and then hopefully Lord Mance in particular has an example as requested of the best case in each jurisdiction. Okay.
Thank you.
So I wasn't proposing to say any more about this,
Right.
than to point
Thank
out we have an example in France, and the bundle references example in Spain, and an example in Italy, and we also, of course, refer to the German cases, this case being the best example. My Lords, my learned friend referred to Pharmacia in Merck as being a good example of an English case where equivalence was found in a chemical case. We agree. It was discussed at paragraph 52 of the Court of Appeal's judgment in this case. And in the decision itself, if your lordships were to look at it, I'm afraid it's not in the bundles. Paragraph 20 of the judgment makes it clear that even though the claim is written as a chemical, the court said nobody who read the specification could believe that the invention was the compound alone, and they read in various functions, in anti-inflammatory functions, into the compound. So that's an example where the court has correctly taken into account the invention in ascertaining the scope of the claims. The court, in fact, didn't apply the protocol questions. It abandoned them. And then it said, in deciding, concluding that there should be equivalence in that case allowed. Otherwise, they said in paragraph 47, claims to chemical compounds would be literal, and that would not be fair. Right. So, my lords, we say that is a good example where the right approach was taken to equivalence on chemical cases in the UK. Finally, my Lord Mance had raised a question of whether the paragraph numbering and the page numbering in some of the German judgments was the same in the published version. My Lord, the paragraph numbering is the same. The page numbering is a little different because the German courts issue a redacted version of the judgment with the parties' names taken out. And so I can hand up the redacted version, so your lordship has the public version. Obviously, because the parties are the same, you also have the private version in the bundles of the German judgment. And I hope that...
How many paragraphs does the redacted version have? The same number as the one?
As far as I'm aware, it has the same number of paragraphs. Yes, it's just that there are, because there are some things taken out in places, the pages get...
It's very curious. The version on the internet has different paragraphing.
Ah, I see, my lord. We hadn't realised that, and I apologise.
Sometimes happens with other courts too. But anyway.
Would your lordship like a copy of the...
Yes, well, fine, yes, thank you.
Sorry to burden your lordships even further.
Very
I promise that's my last
right.
handout.
Anyway, we'll use your paragraph numbering.
What was the reference to the previous case, the English case you referred to?
Yes, my lord, it's Pharmacia and Merck.
Okay, thank you.
My lord, and it's in paragraph 52 of the Court of Appeal, and it's 2002 RPC 41.
Thank you very much.
And if your lordships would like a copy of that, we can obviously provide it. I'm told my learned friend has copies here, so if your lordships would...
Yes.
Right, so
My lords, unless I can assist you any further, those are our submissions.
thank you very much, Mr. Mitchell. Thanks. Mr. Alexander.
My Lords, can I reply principally on prosecution history and then just make a few observations on the foreign law points that have been raised in the recent note. On prosecution history, there are a few points that your lordships should bear in mind. And before we get to the nub of it, it's useful just to have the background in mind. Your lordships were taken to Mr. Justice Arnold's judgment at paragraph 148. And if I could just remind your lordships of that, because this is a sort of run-up to the point on prosecution history that...
Well, this is page 498.
148.
498, is it?
It is 498, that's right. And the reason that it is because Mr. Justice Arnold there discusses the issues that either would or at least may arise if one, in this case, were to have maintained a claim in a broader form, which is now sought effectively to be asserted against my clients by way of the doctrine of equivalence. And that approach that was taken by Mr. Justice Arnold was, of course, a similar approach to that taken by the examiner. And in our submission, it was, whether or not ultimately it would have turned out after a full fight that the patent was or was not invalid on one of the grounds alleged, was at least a good reason for the applicant in this case to say, right, I recognise that there are, or well may be, potential difficulties with respect to validity of the patent in this case, and that is a good reason to limit the patent to the specific embodiment concerned.
Yeah.
And those concerns were not simply, as it were, ill-founded concerns, as your lordships can see from the factual findings to which I drew attention, but would just want to remind you of in the light of what my learned friend said, in paragraph 80 of the judge's judgment, where he was considering the impact of the salt form on a drug in general.
Yes, we've been through
And your lordships have been through that, but if you look at little Roman 2, because my learned friend keeps saying, oh, well, this is all just about solubility and whether it will be soluble. Little Roman 2. We're not just dealing with that. We're dealing with issues of, well, if soluble, would it be stable for long enough? Would it be bioavailable? Would there be impacts on pharmacokinetics? The general point, which was adumbrated at great length in the evidence before the judge, and I'll just give my lords a reference should you be interested in the background. It's Dr. Spargo's report at Appendix 2, tab 10. No, I'm sorry. Tab 13. And I don't invite your lordships to turn to it now, but between paragraphs 420 and 461, Dr. Spargo, who's a very experienced scientist, set out numerous reasons why salt forms would have an impact on the characteristics of a pharmaceutical for a wide range of reasons. And it might be said that is one reason why the PPD of which you were, confidential PPD of which you were shown only one page, is not a single-page document. It actually contains testing of all sorts of kinds relating to this matter. But that is the background here for why, and in a sense, the background known to everyone, including the applicant, and in a sense also known to the examiner, as we'll come on to see, in relation to this matter. The second point, if my lords just go to the judgment of the Court of Appeal.
Sorry, the reference 420 to 461, that's a reference to what?
It's a reference, I do apologise, to the evidence of Dr.
What page number is it?
It is pages MS 982
to 993.
to 993.
Yep. Yes.
I'm sorry, my lord.
Oh, I see, yes, 4.20.
Yes, 4.2021.
Yep.
So if we go back to the judgment of the Court of Appeal then, in paragraph 60,
Yes.
where the judge is considering the file, Lord Justice Floyd, and obviously Lord Justice Kitchen agreed with him, said, in any event, patent office is usually concerned with patentability, not scope. If an applicant were to conclude every letter by saying that he did not accept, that by accepting that this or that limitation he was necessarily restricting the scope of protection, no inference could be drawn from his conduct in accepting that. I'd be reluctant to put patent attorney's profession to this unnecessary trouble. But your Lord Justice has to appreciate what the converse is, that the starting point is that if a limitation is included without a but I'm not thereby seeking to limit, ordinarily the patent profession and the public in general, advised by those in that profession, would say, well, this actually is an effective limitation. And this was recognised not only by the judges in the Court of Appeal, but also by Mr. Justice Arnold, and we would say also implicitly by the examiner himself.
Does this depend on the prosecution history, though, at all? I mean, supposing that there'd been no history and the application had simply been for the patent and form and wording in which it was originally, subsequently, ultimately granted.
No, ordinarily it wouldn't and in a way shouldn't. And this is one of the actual issues in relation to prosecution history, which is that ordinarily it isn't of impact in a case. And the reason it isn't of impact is because the case is decided on the basis of what the patent says anyway.
Yes.
But
are you stronger, therefore, by referring to the circular or the route by which they came to the final wording? You say you are, or not?
Well, you may be. If the argument is put against one, well, you didn't really mean that. Or you didn't really mean that, with emphasis.
You would say if they'd originally applied for that, they obviously did mean that.
Well, indeed, but this was a case, as your lordships have seen in the file, where they actually did make a specific distinction, and the claims that your lordships were taken to in the original patent. There was one claim to antifolates, and then there was a sub-claim to a lymph.
But for reasons which have nothing to do with equivalence, they made the distinction, or they made the change, because they were having some obstructive responses from the examiner.
Well, indeed. But my point, well, this relates to my first point, that these were not simply ill-founded responses from the examiner. They were genuine technical reasons.
Obviously, I didn't mean
in relation to that.
Pejorative. It was his function.
Indeed.
He was just creating a problem for them.
My point, though, in relation to that, is that there isn't this practice of using disclaimers in this sense. If someone says, "Well, this is what I'm claiming," and in contradistinction to what I previously claimed, that is in contradistinction to what I previously claimed, and one sees that in this case. The third point that's made relates to added matter and ignoring parts of the file that address added matter objections. And in relation to that, my lords ought just to bear in mind the general law relating to added matter, and you find that, just for my lord's note, in Authorities Volume 4, Tab 1, because what Lilly seek to do is to effectively say, oh, this is just a mere formality. You don't want to worry about limitations made to address added matter objections. Why on earth should one take those seriously? That's the sort of thrust of their case. And my lords need to understand what added matter is doing, and why this distinction between scope and disclosure doesn't matter in this case. The idea of an added matter objection is to say this: once you've put in your patent application, you've disclosed your invention, you've done so on a particular date, the filing date. You may be able to claim priority back to another date. And what you ought not to be able to do is to then seek to improve your position using possibly after-acquired knowledge after you've put your application in.
Yes.
And that policy is reflected in the case law of this country and in the EPC, and my lords see that in the extract from AP and Alcon, referred to in Terrell at 15.35, MS 4268. And so, although it is true that a claim may claim more than the disclosure discloses, that's nothing to the point as to whether an objection or amendment to take account of added matter should be dismissed as a formality. It isn't, and it wasn't in this case, because the reason for the amendment being raised is to say, well, look, previously you claimed antifolates and a specific subclaim to pemetrexed disodium. And now what you're seeking to do by putting in pemetrexed is actually claiming something different, namely a term that ordinarily would mean pemetrexed diacid. And in those circumstances, we're not going to allow you to do that because these are two different chemicals. We'll hold you to what you originally claimed. So there's no basis for saying that there is a distinction between prosecution history based on added matter and other objections. And the judge, in our respectful submission, rightly recognised that and analysed this correctly in paragraph 112 of the judgment of Mr. Justice Arnold. And again, we don't need to take it out now, but this argument was put to him, and he analysed carefully why that wasn't the case. And indeed, it is not an argument that is accepted either in the AIPPI guidelines or in Holland, France, Italy, or Belgium. And in our respectful submission, there is, as the judge said, no good reason why the prosecution history should only be useful as an aid to construction in the former type of case and not the latter.
Yeah.
And we respectfully commend that to you.
So that was which paragraph in his judgment?
112 of the judge's judgment.
The judge, yes.
That wasn't addressed in the Court of Appeal because, of course, Lord Justice Floyd took the view that none of this ought to come in at all, essentially. So the distinction between one aspect and another didn't arise.
Yep.
So finally, may I address your Lordship on 2 points specifically relating to the file here. First, if you just take up bundle appendix part 2 and go for the last time to this correspondence.
Last time in court, yeah.
My lord, yes indeed. And turn to tab 10.
Yep.
This picks up on a point that I had just foreshadowed, where the examiner came back to Lilly and said that if you're putting in pemetrexed, prima facie, pemetrexed, in the wording of these claims in the corresponding passages, is certainly a distinct compound, and they refer to the CAS registry number of that compound, which is actually the diacid.
Yes.
And contrasting it with pemetrexid disodium. And just for my lord's note, a CAS registry number was something that was canvassed in the evidence. There was no doubt about it. It's an entry relating to a specific chemical.
Of course.
Either a specific salt and so forth. So this is just language. It's
What's it stand for, CS? Chemical something?
Chemical Abstract Service, I'm told. And so these were two distinct compounds. Of course, the examiner didn't come back and object. The applicant didn't come back and object to that because everyone understood. Yes, of course, these are distinct compounds, which is why the applicant came back and said, "All right, we give in. We'll yield to your observations, which prima facie were justified, and actually claim the preferred embodiment." And that is what you see was done in the subsequent letter. There was no real confusion here on the file at all. It's also said in connection with this that the objection was just an added matter objection, and just so that my lords are clear about that it's true that the final exchange of correspondence was focused on Article 1232, but if you just turn back one tab to tab 8, page MS 943, and we didn't look at this in great detail because it doesn't really matter for the purposes of the case, but it is important to understand what was going on here in the light of what was said. The examiner came back and his initial objection was, wait a moment, your claims that you seek to maintain in this broad form are not novel. And the reason that they're not novel is because there are prior art disclosures of the use of vitamin B12 with other anti-cancer drugs for addressing various side effects. D1 was a reference to that effect. We don't have it here, but it doesn't really matter. D2 on the next page discloses the use of vitamin B12 therapy.
Sorry, where's D2?
I'm sorry, it's MS 944, second paragraph. Yeah. Compounds optionally in combination with methotrexate, which is obviously a very well-known antifolate in the treatment of cancer. And so effectively what the examiner was saying was, well, your invention needs to be limited in any event. And then your lordships have seen the limitations in question. Equally, there were inventive step objections, which ultimately were also overcome. So what one can't say in this case is that there was, in any event, a pure added matter objection in that situation. So in our submission, in relation to the file in this case, if this isn't a specific enough limitation, one really doesn't know what would be. And for leaving aside the question of admissibility, if this is not regarded as sufficiently specific to say, well, what we are claiming is pemetrexid disodium and there are good reasons for it, it would be very difficult to see a situation in which that was actually the case. So can I then turn on to the policy reasons for not admitting the file? First of all, the number of cases, Well, as your lordships know, the number of cases in which this is likely to be an issue first should not be great, because ideally people will make clear what they are claiming in the first case, ought not to create an undue burden, and it might be said that we don't see necessarily litigated the cases where there has been a clear indication of a specific claim on a file, because patentees would not assert those claims against anyone else, because they recognise that the limitation has been made. Secondly, in relation to AIPPI, we say, well, that supports our position. Obviously, it doesn't suggest that there's any distinction between added matter limitations and any other kind of limitation. And we would submit that the AIPPI would be rather surprised if this kind of limitation hadn't been regarded as a sufficiently serious one in this case. Obviously, they're not addressing specific cases. In relation to the issue of pre-contractual negotiations, I don't submit that there's a direct analogy. There isn't, and partly because in contract one doesn't have a controlled administrative or quasi-regulatory process. These are submissions prior to adjudication. They are not negotiations prior to conclusion of a contract. And in relation to submissions prior to adjudication, we respectfully submit that there is a much clearer basis for admitting documents which show the basis upon which the adjudication was reached. So in our respectful submission, there isn't a problem there. In relation to TBA proceedings where there's no agreement even as to what happened at the TBA, these are proceedings where there isn't a verbatim record anyway, and people take minutes and so on. There may be different considerations, and no one is suggesting that the file has to be taken into account in every case, or that the file will be determinative in every case. To the contrary, all we're saying is that there should be no exclusionary rule that says it can be of no utility and not taken into account in any case. That would, in our respectful submission, be to go too far. So in our submission, there are no policy or reasons specific to this case for not taking the file into account, and it adds weight to our point in relation to specificity. On the other points that have been handed up, on foreign law, this note, although we have looked at it briefly over lunch, is somewhat more formidable than we were anticipating, to be quite honest. And what I was going to suggest to my lords was that we limit the proliferation of documents in this way by not providing a counter-document, but by taking this document, if our opponents were prepared to provide it in Word, and just putting some brief annotations on it and sending it to you so that you don't need to listen to us in relation to this now, if that would be acceptable. I haven't discussed that with my learned friend, but it might be a convenient way of proceeding. Similarly, there are key foreign chemical cases. Well, we haven't checked as to whether these are all the ones that you might want to look at others. It might be useful just to add something in relation to that. There are brief points that one can make in relation to that, and I'll confine myself here to prosecution history. Once it's been found that the prosecution history is preclusive, because it is clear in one jurisdiction, to say, oh, well, there are other jurisdictions which make a clear distinction between the degree of definiteness of a file, when none of the experts suggest that this is actually the case, is a difficult thing to do. And we would respectfully submit that Mr. Justice Arnold, in his reference to the Hewlett-Packard case in France, was absolutely correct. And you see the file was in fact taken into account and was determinative. In Italy, similarly, there was a basis for taking that into account and holding it was determinative. In Spain, where the basic law is similar to here, again, it's entirely proper to take the prosecution history into account, and the statements don't indicate any unambiguity. They are precise, conclusive, and made for good reasons, technical and legal. So in our respectful submission in relation to these matters, we would say that the position is absolutely clear in relation to the prosecution history aspects. In relation to indirect infringement, I don't think there's anything else that I would wish to add. The debate has been rather sufficiently canvassed this morning. I sought to answer the points that my learned friend made in advance and during the address. The central issue is and remains whether it's right to say that essentially pemetrexed dipotassium is used in the method of manufacture of pemetrexed disodium when there's simply a dilution which is contemplated in any case. So that's the way that we'd respond briefly in relation to that. So, unless your lordships have further questions, those would be my submissions in reply.
Oh, thank you very much indeed, Mr. Alexander. Thank you.
My Lord, I would only end by apologising for slightly less smooth presentation than you might have been wanting from me, but as you may know, I've been brought in relatively late to this case for reasons that were explained to your lordship.
Rather sad
separately.
reasons, yes, we understand. Well, nobody would have guessed it, Mr. Alexander. Thank you. Mr. Mitchison, Mr. Alexander's proposed a way of proceeding in relation to the foreign law matters. I can't expect you to give him a blank cheque in terms of what he writes. On the other hand, there comes a point where there's a limit to what can be said. I suggest that you provide him with a copy of what you provided us with in word form. He puts in what his brief comments, shows them to you. If there's anything you feel you have to reply to, then I don't think we can stop you. But I would hope you would, on the whole, manage to restrain yourself. Is that the best way to proceed?
My Lord, we'd be entirely content with that.
Okay, right. Well, thank you both very much indeed, or in fact all four of you, for your submissions, which have been made very clearly, if I may say so, in this technical and complex case, and finishing pretty well within time. And we're also grateful to everyone who was involved in preparing the written cases, which we found very useful. We will, unsurprisingly, consider this matter and let you know our decision in due course. Thank you all very much indeed. Court's now adjourned.